Hi, this is Katie Toole with Garden Plain High School, and my second YouTube video topic is student drug testing. So today we're going to look at different court cases that have involved student drug testing and what can be done legally by the school system. First of all administrators need to be aware that No Child Left Behind plays a role in student drug testing because the main source of No Child Left Behind is the fact that it maintains that administrators need to have a safe school environment, and schools actually must have plans in place to provide a safe and drug-free environment. And there is federal money earmarked for strengthening school safety as a part of No Child Left Behind. Secondly, the legalities of the Constitution come into play. The Fourth Amendment, dealing specifically with search and seizure, states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And then the second is the 14th Amendment, which deals specifically with due process. It states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And in the school system, students do have the rights to the 4th and 14th Amendment. They are protected to a certain degree. The legalities of a drug testing policy in a school. Students do have the right to procedural and substantive due process. Procedural due process means that certain legal procedures are followed to maintain fairness and to avoid arbitrary actions of school officials. Substantive due process means that a valid reason must be present for a student's rights to be restricted. And in order to satisfy the 14th Amendment, both procedural and substantive due process must be met. There are several court cases to examine, the first one being Veronia School District versus Acton, 1995, and a prospective student athlete challenged the school district's policy which required all student athletes to provide a urine sample. The Supreme Court held that the drug testing was constitutional and reasonable for 3 reasons. Number 1, the student athletes have low expectations for privacy in communal locker rooms where samples are given. Number 2, the testing program was unobtrusive, with samples given in private, and the testing was handled by an outside agency. And number 3, the program was shown to be put into place to combat the drug abuse that was happening at the school. And the court found that as school officials, we do have an obligation to try to combat drug abuse, and the drug testing policy was considered to be a valid one. So more court cases. The second one, the Board of Education of Independent School District number 92 of Pottawatomie County versus Earls, actually took place in Oklahoma. The date 2002. The court upheld the drug testing policy was constitutional since it was meant to combat drug usage. It was a warrantless suspicion search of urine samples of students in all extracurricular activities that prompted the case. And the particular student was actually a member of National Honor Society and something similar to a Scholars Bowl. And when she was asked for a drug sample, or urine sample, I'm sorry, she refused. So that prompted that court case. A third court case, the U.S. 7th Federal Circuit Court of Appeals, heard Todd et al. Versus Rush County Schools in 1998. And this one's very interesting. All students were unable to participate in any extracurricular activities and or driving to and from school unless the student and parent or guardian consented to a test for drugs, alcohol, or tobacco in random unannounced urine samples. The random testing program was upheld as consistent with the 4th and 14th Amendments. I found this court case to be extremely interesting just for the pure fact that the school district decided to restrict driving privileges and did not allow students to drive to and from school unless they participated and consented to the drug testing. And this was held to be constitutional. So the court system found that policy was indeed constitutional. So what can schools do? Well, districts can implement drug testing policies that fit the needs of the individual district. So the courts have repeatedly found that schools with a history or knowledge of drug problems can implement drug testing with the intent of creating a safe and drug-free environment. The policies must be in place that prohibit drug alcohol usage and the consequences that would take place if someone partaked in that activity. The parents and students must have knowledge of the policy and consent to it, and schools are encouraged to create drug and alcohol education courses to teach students about the harmful effects. As far as the ISLIC standards go, standard number 3 states that an education leader promotes the success of every student by ensuring management of the organization, operation, and resources for a safe, efficient, and effective learning environment. And by doing this, we are expected to promote and protect the welfare and safety of staff and students. And I feel like having a drug testing policy would cover this standard. By doing so, you are trying to protect your whole school population and reduce the incidence of drug usage. Standard number 5, an education leader promotes the success of every student by acting with integrity, fairness, and in an ethical manner. And by doing so, we are expected to safeguard the values of democracy, equity, and diversity. And once again, I feel that as a school administrator, it's our job to act with fairness and also to provide students with due process. And by doing that, we would then be compliant with the court system and be upholding the 4th and 14th Amendments of the Constitution. My references, I did use the Essex textbook from the class and also 2 different websites. First one is Prevention Not Punishment, which is a very good website showing different court cases. And then the second one was a student drug testing program document from the Arizona State Department. I hope you've enjoyed my presentation and learned a little bit more about student drug testing and what can be done within the school system. Thank you.